supplemental list for judgment. Item number 1, SCRL Proceedings of 2010.
In view of the foregoing discussions, we are of the humble view that the prosecution has failed to establish the chain of unimpeachable evidence against the appellant. The circumstances of this case have no definite tendency to unerringly point towards the guilt of the appellant, and that it cannot be said that the circumstances adduced by the prosecution only point towards the conclusion that it is the appellant and none else who was the author of the crime. There is a long mental distance between may be true and must be true, and the same divides conjectures from sure conclusions. Even though a 7-year-old child has lost his life and a grave and heinous crime has been committed, but since there is no satisfactory proof of guilt against the appellant, we have no other option but to give benefit of doubt to him. Accordingly, the impugned judgment and order of conviction of the appellant under sections 302, 364, 201 of the IPC is not sustainable in the eyes of law, and the same is hereby set aside. The appellant is acquitted of all the charges. The appellant is in judicial custody since 17 to 2007. He be set at liberty forthwith if his detention is not required in any other case. In the result, the JCRLA is allowed. Before parting with the case, we would like to put on record our appreciation to Mr. Vikas Chandra Parija, advocate for the appellant, for rendering his valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Jateshwar Naik, Additional Government Advocate.
I agree.
For judgment. Item number 2, SCRL 62 of 2009.
From the available materials, there appears to be no evidence of long-standing and insignificant animosity between the appellant's family and that of the deceased. While there is a reference to a monetary dispute that allegedly occurred 2 months before the incident, the time gap diminishes its direct relevance as a motive for premeditated murder. Instead, this dispute may explain the appellant's underlying frustration and agitation, which led to the violent act. However, the manner in which the weapon was used, specifically the blunt side of the spade, to inflict the injuries doesn't fully align with the criteria required to establish murder under Section 302 IPC. Rather, the appellant's act is better classified as culpable homicide not amounting to murder, punishable under Section 304 Part 1 IPC. The evidence establishes that while the appellant acted with knowledge and intent to cause serious injury, the intention to cause death is absent. It supports the conclusion that the appellant acted with the intent to cause grievous harm, which, given the circumstances, is sufficient to bring the offense under Section 304, Part 1 IPC. This classification acknowledges culpable nature of the act while distinguishing it from the heightened intentionality required for murder. In view of the above, the conviction of the appellant is altered from Section 302 of the IPC to one under Section 304, Part 1 of the Indian Penal Code, and the appellant is sentenced to undergo RI for 10 years for the said offense. In the event the appellant has already undergone the substantive sentence as above imposed by us, and his detention is not required in any other case, he shall be set at liberty forthwith. Before parting with the case, we would like to put on record our appreciation to Mr. Satyanarayan Mishra, Advocate, for appellant, for rendering his valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Aravinda Mohanty, learned additional standing.
I agree.
Obliged, man.
I have an infection in my left eye. So I'm advised by the doctor to take 3 days rest, not to give any study.
You have any matter in the case?
Yes, I have got 2 matters, item number 28 and 33. That can be adjourned to maybe adjourned next week. Item 28 and 33.
28 and 33. Mentioned by Mr. Jan Kumar of Senior Advocate. The matter is adjourned next week. This matter will be commencing from 2nd December 2020. 2nd December 2020.
Yes,
Lordship, please to mention item 29, 31 and 38. Mr. Surya Mishra, Senior Counsel, he has some problem, requested me to take adjournment for next week.
Which one?
29, 31, 38. He suggested that yesterday he mentioned
29,
31.
and again 38.
38.
Aye.
Mention is made on behalf of Mr. S.P. Mishra and Senior Advocate to adjourn the matter. Next week, though,
Monday,
is this matter on 2nd of December 2020.
Monday,
कहली पड़ा 2nd December ta Monday la nahi.
May I be pardoned? My lord, WPC 14454/22. Maybe come.
Please give the list.
Item 35. My lord, item 35, we are I along with Mr. S.D. the Senior Advocate is appearing for OP MCL. But we seek
Item
35, my lord.
Yes.
My lord, we seek 2 weeks time to file the counter. It is we filed. We have not filed the counter.
All right. A mention is made on behalf of Mr. S.D. Das and Senior Advocate to adjourn the matter for 2 weeks to file the counter affidavit. This matter on such and such date. Copy of the counter affidavit be served on the Land Council for the petitioner who is at liberty to file the rejoinder affidavit. Give a date.
Mention WPC number 24046 of 2022 is pending for last 2 years, my lord. It is a senior citizen.
Supplemental list, item number 3.
May I please your lordships? During pendency of this matter, lordships, a possession notice was issued on 14/11/2024. Now that possession notice has been challenged by me in another subsequent petition, which is diary number 49675 of 2024. Lordship, I have day before yesterday I filed the diary number. Only I am supplying the copy to show that the possession notice. That is at page lordship 12.
But it's all right. The matter would come.
Yeah.
This matter would come along with that. In the next Monday, it will come. What is it?
Lordship.
The learned counsel for the petitioner submitted that in the meantime, possession notice has been issued by the opposite parties for which the petitioner has filed another writ petition before this court, and it is registered as
Defect writ petition.
DWPC number 49675 of 2024. The land counsel for the petitioner files the copy of the writ petition, which is taken on record. Let the land counsel for the petitioner remove the defects in the aforesaid writ petition so that the same can be listed with the present WPC next week on being mentioned. You remove give a memo so that it will come in the next one.
Lordship.
Item number 4.
The item number 4, my lord. Also to lordship's order dated is there. The instruction has been sought for because in the meantime this honorable court has sought for instructions from the government on 6/3/2024 about the clarification or fixation of it.
What is the last order you have?
11
So we
26 to 24. Yes.
26/3/2024 पर आउरी order passing.
No. 26 to 24. Thereafter, letter has been corresponded from this honorable court to the Department of Homes for clarification on 6/3/2024. That
6/3/24
for clarification टा माने this special officer administration of this honorable. It has not come. I pray for
please pass on.
From the registry side that has.
To obtain it, land counsel for the state. You are appearing for the state as well as for the opposite party number 2 and 3. For all the opposite parties. The land counsel for the opposite party submitted that after the initial order dated 26/2/2024 was passed, this court has sent a letter that is letter number 4082 dated 6/3/2024 regarding clarification for the fixation of pay of the petitioner was the bench clerk grade 1 of fast track special court FTSC, Bhavani Patna. However, no response has been received, and it takes 2 weeks time to obtain the instruction. Put up this matter, give a date, instruction be obtained in the meantime. Learned counsel for the petitioner is present. Acha, the letter is taken on record.
Item 5.
My lord, I beg apology, my lord. On the last occasion, my lord, I couldn't appear before your lordship because I was suffering from I had very pain in my chest and I had to rush to AIMS, my lord. Because earlier I had an heart attack. I was suffering from cardiac problems. Lord,
Have you deposited that 10,000
my
rupees?
lord, I couldn't, my lord.
Why?
My lord, the cost has been imposed on the Union of India, and because of my latches, my lord,
Whatever it may be, you have to
My lord,
deposit that
I
amount.
have filed an IA for
May I audible, my lord? May I audible?
Sorry.
Yes, yes.
May I audible?
We are not
My lord,
going
I'm extremely apologized on that day. Neither myself and 6 that has been taken right lordship path order. Excuse my lordship may recall the order because of this that day he was in AIMS for his next checkup after angiography.
No, that day, that is all right, Mr. Pari, but
But what you have taken 6 times, I'm apologized, my lord. This
you have mentioned why we
not,
imposed the cost. And
that's why
the
I
adjournment
lordship,
was
I'm not
found.
stand on the way of the lordship, but I'm excuse myself, lordship, apologize, my lord, this system. Lordship may recall
No.
this.
After 6 times, if the adjournment is again sought for, then
No, my
that is the
today
reason.
he will argue the matter. He is ready with the argue the matter. Only lordship may
It's
recall.
all right, but deposit the amount if
Or lordship may reduce some amount, we will pay this.
no,
Whatever.
that's not expected that we should not. Unless the amount is deposited, we cannot hear the matter. It's not that after 6 adjournment, you are taking adjournment.
Hey, see, lordship is right. The order I am not interfering. Only I am apologize, my lord, this because our mistake is our part.
Deposit the amount.
Admittedly, it is mistake is our part and
Deposit the amount. Yes. IN number.
My lord, may I pray, my lord?
IN number so and so is
My
for
lord, may I
recalling
pray,
the
my
order dated 18/11/2024. After hearing the Land Council for the Union of India, we are not inclined to recall the order.
within 10 days, my lord, within 10 days.
Mr. Pari submits that within 10 days the amount will be deposited. As ordered in this one, so it will be deposited in the Orissa High Court Advocates Welfare Fund.
My lord, yes.
Of this matter after 10 days. Give the date. Yes.
My lord, may I pray, my lord? The cost may be imposed upon me, my lord. Not on-
Sorry. Yes, next.
Item 6.
Great, my lord.
Item 6, your lordship, in this case, one amendment has been filed while filing this matter. Inadvertently, certain annexures which has been part of the original application and which has been challenged before in the original application that could not have been filed. Lordship, there is an annexure 13 to 16 in the OA. My lord, allow me to file those annexures, rename the pages so that it can be heard. And
you have filed this
amendment
application for amendment.
Your lordship.
So who is appearing for the other side?
It's an admission matter, your lordship. No one is appearing yet.
In the petition, notice is not issued. That's why.
All right. IN number 13644 of 2024. This is an application for amendment. After hearing the Land Council for the petitioner, so also going to the amendments taken in the interim application, we are inclined to accept the prayer made in the interim application. Accordingly, amendment sought for is allowed, and the schedule shall now form the part of the writ petition. The Land Council for the petitioner will file the consolidated writ petition within a week.
Within a week.
Matter will
Obliged.
thereafter. Yes, next.
My lord, item 5 posted to 10 days after.
Item 7.
Pay, please, lord. The petitioners of the employees of the opposite part number 3, their advertisement was prior to 2005 after the pension rule came into force, but they joined after that. The law has been settled by this honorable court, which has been upheld by the honorable Supreme Court. Their cases to be considered as per the old pension rule. Accordingly, we have filed a
Mr. Das, you
petition to
have
the
gone
government.
through your annexure, no?
Pardon, madam?
You have filed annexure for
Yes, my lord.
Page 25.
My lord.
So the order is of the Government Home Department, para second.
My lord.
Whereas all the applicants filing OA cases have joined in between the dates 1/1/2005 and
Right.
17/9/2005. Here the question of
So that is
advertisement was not there.
fact of that case.
Yes.
That is the fact
So,
of that.
no. That is how the Ananda's case has to be followed. That is the
No,
ground.
Ananda's case, my lord, they joined in 2006.
Who?
Anandas and others. That our Odisha High Court judgment.
They had joined in 2006.
Yes, my lord.
Kindly see.
Many other cases also been disposed of. A batch of cases also.
But those are, in fact, no. The
This is
cases, fact of the cases are different in all the cases.
All the cases. But the ratio decided in the Ananda's
The
case
ratio
is
decided is if they have joined
the
in
process
between
has
this
started
period.
prior to 1/1/2005. But because of the delay in the process of recruitment, it has been joined after 1/1/2005. Their cases will be governed under the Pension Rule 1992 and the OGS, GPF Rule 1938. That is the ratio essential. So at this juncture, my lord, because number of cases, I have also the orders of the subsequent order where they are rejected by the government. I came before this honorable court. I will be counseled.
No, we have passed order, you see. We have passed
my lord's order, I could not get it. I'm all these two
we have
orders.
already passed order.
That my lord, kindly see. This is a batch of cases I was doing. I was holding it. This is by my lord Justice, then Chief Justice.
No, when did they join?
October
October
2005. Annexure 2.
ସେଇଠି ସେମାନେ join କରିଥିଲେ ରେ.
That is the fact of that particular case. That is why that has been taken over.
No, that is the ground probably it is taken.
The government has taken. These are the government establishment that I one of those document I have filed. Another case of Ganjam district I have filed our judicial staff.
So,
my lord, direct
you examine
Yeah,
this,
let the copy be sent.
let me do the writ petitioners. Are working. Why have you joined them in one writ petition?
My lord, one advertisement, one order of appointment. All were appointed in one order. Annexure 1 is the advertisement, single advertisement.
Joining is also one.
Yes, ma'am. So
What
good order of appointment is also.
What about the court fees?
Court fees I have paid. That extra additional court fee. Otherwise, it would not have been listed, madam.
Oh,
That is a defect. Now it has been changed.
The petitioners are working in various posts in different districts.
No, madam. The justice, what is justice?
In the justice of Bhawanipatna.
My.
In the justice of Bhawanipatna. They have prayed to include the name in the General Provident Fund Orissa Rules 1938 and Orissa Civil Service Pension Rules 1992 by allowing them a GPF account number and grant them all consequential service and financial benefit within a stipulated period. The Land Counsel for the petitioner submits that the ratio decided in the case of Anandas versus State of Orissa in WPC number 15433 of 2012. এটা কেবে dispose of হয়েছে?
My lord, dispose 24/4/2013. Reported in 24/4/13.
13 না 23?
13. What about the type? Reported in 2014, supplementary 1 Weller 752.
2014? Yeah.
Supplementary 1
Weller 754.
Weller 754.
1754.
My lord.
Reported in Swan, so is applicable to the present case. Land Council for the state accepts notice as a issue notice on the question of admission, indicating therein that the matters are disposed of at the stage of admission. The Land Council for the state accepts notice for all the opposite parties. Let the extra copies of the writ petition be served on the Land Council for the state, and matter be listed 4 weeks after present. Counter affidavit, if any, be filed in the meantime. Yes, next.
Next item, same my lord, only the ship is Ganja.
Just is
Ganja.
Ganjam.
Se seat thila transfer is. Same advertise.
बाकी सब सेम रहेगा खाली just is that.
Item 9.
Annexure 6.
The representation annexure 6 is
OP3
OP3.
Right.
OP3 is to dispose. Huh?
Item 10.
I submit, my lord. My lord, this is a case of delayed payment of leave encashment. The petitioner was removed from service in 2019, and when he applied for payment of leave encashment, he was not being given and he was denied. Later on, he filed an OA before the learned tribunal, and tribunal granted leave encashment. But for payment of interest for delayed payment, though it was pleaded directly for payment of interest, and it was denied by learned tribunal.
The specific order to that effect was passed.
Yes, my lord.
Where is that order?
But I have not enclosed, my lord.
Then
In the letter, another way.
no, you are, Mr. Counsel, you are claiming now that the interest on the delayed payment of leave salary.
My lord.
So you say that in the original application there was a prayer for that, and the learned tribunal has refused. So you are supposed to file that order.
My lord, in the OA application, it is not specifically mentioned that to.
Then how can
That is why it is put to you.
Why, if your
But-
prayer is not there, then why the
Tribunal will grant it.
tribunal will grant you?
My lord, orally it was pleaded.
No, orally that's not. If you want, you can make another original application. We are disposing it of, giving you liberties on.
My lord, I have submitted one original application before the learned tribunal. It was rejected on the ground that in piecemeal you cannot ask for relief.
So, the matter which you could have earlier asked for.
Now, this very matter, earlier there was no prayer.
No, original, it was not written in writing. It is not there.
Then you filed another original application.
Another original application for delayed payment, which is rejected, and it is the subject matter of this writ petition.
So what is the wrong?
My lord, he was removed from the service.
No. How do you meet this? It's a position of law.
My lord, when they have delayed payment from show motor.
No, that is there. That is the factual aspect that the payment is delayed.
My lord.
Now, question of interest part has not been prayed by you before the Central Administrative Tribunal.
My lord.
When you are coming for the second time, the tribunal is taking a view that you cannot come in piecemeal.
My lord.
So, what is the law basing on which you now expect?
If admitted, I can cite judgment of Honorable Apex Court. When they have used my money, they got benefit out of that. Suppose they are under the interest act.
No, you are in a different thing. The tribunal has rejected your application that you cannot make it in piecemeal, meaning thereby the prayer which you could have made in earlier way has not been made. So, does it stand as a constructive res judicata? That you have to say on. If it is a res judicata, then you cannot. If you can show that no, I could have brought and a separate OA can be filed, you come on that only.
It was pleaded.
That is suffice.
Pleaded orally pleaded, not
Again.
in writing.
Again, we are asking you on a point of law. Please examine it.
Yeah, examine it.
Please examine it. Whether in such circumstances, whether it would be you will be deprived of that if he files a separate original application. If in the original application there must be a prayer and such other relief as the one should think deem and proper. It generally thai prayer relief short for.
But
Just
saving-
listen to
saving-
then answer. Without listening, if you try to answer, you will know.
Well,
ଆପଣ ଗୋଟେ ରିଟ୍ ପିଟିସନ ରେ ଗୋଟେ ପର୍ଟିକୁଲାର ପ୍ରେୟାର କଲେ ସ୍ପେସିଫିକ ପ୍ରେୟାର
my lord.
ଏବଂ ତା ଛଡା ଗୋଟେ ଲେଖୁଛନ୍ତି ଆଣ୍ଡ ସଚ୍ ଅଦର ଅର୍ଡର ବା ଆଜ ଡିମ୍ ଫିଟ୍ ଆଣ୍ଡ ପ୍ରପର
My lord.
ତେଣୁ ତାର ସ୍କୋପ
ସେ
ବହୁତ
କଣ?
ଭାଷ୍ଟ
Yes.
ରହୁଛି ହେଲା ଦ୍ୟାଟ ହାଜ ବିନ୍ ଡିସାଇଡେଡ ବାଇ ଦି ଡିଭିଜନ ବେଞ୍ଚ ଅଫ ଦିସ୍ କୋର୍ଟ ଯଦି କୋର୍ଟ ଇଏ କଲା ଯେ ଆପଣଙ୍କର ଏଇ ରିଲିଫ ଛଡା ଯୋଉଟାକୁ ଆପଣ ସ୍ପେସିଫିକ treat କରିଛନ୍ତି ଆପଣ you are also entitled to get that relief. The court is not helpless. The court cannot say that no, subject to think that it is connected to that. ତେଣୁ Justice Hansaria's decision ଦେଖିବେ that is there that and such other relief ର ମାନେଟା କଣ ତାର ସ୍କୋପ ଟା କଣ ତେଣୁ ଆପଣଙ୍କର ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ରେ ଯଦି ସେଭଳି କିଛି ଇଏ ଅଛି ତେଣୁ ଯଦିଓ ଆପଣ ପ୍ରେୟାର ନ କରିଥିଲେ यार मध्य पावर अच्छी ट्राइब्यूनल रो से रिलीफ दबा पाए just examine that and also examine what my esteemed brother has pointed out that whether it would be the constructive rejudicata or not. Come prepared, we'll take up this matter next week.
Okay, sir.
The same applicant has a two cases. Another is 10, another is 12.
How? And the other one is?
12.
Well, my lord.
That is what?
That is RTP, my lord.
That is for regularization.
My lord, in 1980,
No,
government-
just a minute. Item number 10,
Yes.
the Learning Council for the petitioner 6 adjournment till next week. To place the earlier original application filed by the petitioner, so also some citations to show that constructive res judicata is not applicable in the case in hand. This matter in the week commencing from 2nd December 2024.
Item 11.
And in this case, our appearance may be noted
Hana lekhavo.
along with BK party. Along with BK party. I provide the list to the court, my lord.
सर जहाँ को ना से कौन ଆଉ କହିବା ଦରକାର ନା ପ୍ରତ୍ୟେକ matter. That is better, Mr. Padi.
Yes. That's why I'm not bothering the court. I've given list. Yes.
Because that is better. Yes,
Right.
and 11.
My lord, the petitioner is recognized by the collector as the displaced person. Annexure 9, page 44, coming under E category, page 44. My lord, last one, the petition is coming under category E as per the RR policy 89. But my prayer, I am coming under either C or D. So, my lord, the letter on the documents received under RTI, I have lost the entire homestead property, page 47. Page 47, my lord, they have given me under the RTI.
Representation ଟା କେତେ number?
ସେଇଟା ବି previously annexure 12 also
recently representation ଟା କେତେ?
49, ମାନେ page 49.
Annexure 12 ତ?
ହଁ ସେଇଟାକୁ decide କରନ୍ତୁ in view of annexure ମାନେ ଯୋଉ documents ଟା annexure 10.
ସେଇଥିରେ ଲେଖି ନାହାନ୍ତି annexure 12 ରେ ଲେଖିଥିବେ ନିଶ୍ଚୟ ନା?
ଆଜ୍ଞା,
annexure 12 to be disposed of, yes.
ଟିକେ ମାଇଲେ ମୁଁ ଲେଖିନି ସେଇ ଯୋଉ documents ଟା ପାଇଲି RTI ରେ
ଲେଖି ନାହାନ୍ତି ତ fresh representation ଦିଅ।
କିଛି indicate
Fresh ସେଟା ବି 23 ର ଆପଣ ଦେଇଥିଲେ।
Prayer is this and he wants to file a fresh representation within 2 weeks. If that is to be disposed of within 3 months and order to be completed with 15 days. So detailed representation.
Yes. Before the OP number 2, my lord. ମୁଁ 2 କୁ ଦେଇଥିଲି।
Opposite party number. Yes, next.
My lord, may I pray? Sorry, my the
କଣ ବାବା
No, my lord, with due respect, my lord, ମୁଁ RDC ଙ୍କୁ ଦେଇଥିଲି, RDC ଏଥର ପାର୍ଟି ହେଇନାହାନ୍ତି. I may be allowed. ମୁଁ ସେ representation ଟା
RDC contribute ହବନି
RDC
ଓଭର ହେଇଯାଇଛି
Representation ଟା କାହାକୁ ଦେଇଥିଲେ?
ମୁଁ ଦେଇଥିଲି RDC କି
RDC
ସେ
not a
having
party
been obtained liberty page 48 ରେ ସେଥିରେ ସେ
ଆପଣ କାହାକୁ ଦେବେ ବର୍ତ୍ତମାନ କାହାକୁ ଦେବେ
ମାନେ RDC
RDC ଙ୍କୁ ଦେବେ RDC dispose of କରିବେ yes next
ମାନେ opportunity ଆମ documents ଟା ଦେବି produce କରିବି
if necessary opportunity of hearing
My
yes
Item 13.
12
ଟା ବା କହିଦେଲେ ଆପଣ ସେତେବେଳେ
ଗଲାଟା
ନାଇଁ ନାଇଁ
May I submit, my lord?
yes
My lord, this is a case. Government of India for Postal Department in 1980 issued a circular for recruitment of postal assistant, setting assistant, and accounts assistant. For example, if there will be 100 posts, they will recruit 100 posts in merit list A and another 50% of the post as reserve category. They will be given similar training, but when the group B will be working, they will be paid 2 rupees per hour for 8 hours, maximum 500 rupees per month. But those who are in merit list A, they will be getting full salary, leave benefits and everything. My lord, this was challenged before the Honorable Learned Cat Jabalpur in 1986. My lord, Appendix B, list of dates. In 16/12/1986, Learned Cat Jabalpur has given the order that this violates the Article 14 and 16 of the Constitution.
You are
Paragraph
jumping,
number 19 page 170 and internal page number 14 of the judgment order passed by the London Central Administrative Tribunal. Page 14, internal page 14 of the tribunal's judgment and running page is 170.
My lord.
Paragraph 19. Please place it.
My lord, page number 170.
170.
Mr. Naik, ସେ ୱାକମ୍ ରେ ଟିକେ ବାହାର କରନ୍ତୁ କାହିଁକି
My lord, equally, it is settled principle of law that a settled thing should not be unsettled after a long lapse of time. Further, it is well settled law that the person who shall be affected in case of relief is granted to an applicant must be arranged as party to the litigation. In the present case, the applicant were appointed as PA during 1986. They woke up from the slumber by making representation in 2018 after a lapse of more than 3 decades, praying inter alia for their regularization of their services from the date of their initial enrollment as RTP for granting a financial upgradation under TBOP and MSCP on the analogy that RTP employees who are not regularized approach the various tribunals wherein orders were passed to regularize them retrospectively. But no explanation is forthcoming for not being vigilant, if at all they had acquired an indefeasible right to be regularized from the date when they were inducted as RTP starting from the day they were appointed as PA in 1986. Therefore, allowing the benefit by condoning the delay would be tantamount to unsettling a settled matter after about 3 decades. Further, direction of retrospective regularization at this stage would much more adverse repercussion, effect, and it may so lead to offsetting the promotional effects, etc., affecting the right of the others who are not before this tribunal. Hence, taking into consideration the entire aspect of the matter, this tribunal is well convinced that this matter where no leniency can be shown to the applicant. On examination, we find that the facts and issues of the earlier OA 534 of 2019 are same and similar to the present case, and therefore we see no justification to differ from view already taken by the applicant in the aforesaid case. My lord, in OA 534 of 2019, already we have preferred an appeal before the Honorable High Court. This is an order issued by Division Bench of Power High Court already notice issued and counter is asked to the respondents.
So you mean to say that this matter is to be heard along with that?
My lord.
You are the same person.
Of same batch, my lord, same cadre, different person, my lord.
We find that the issue, facts and issues of the earlier shown are the same. Acha, who has filed those? We 534 of 2019.
My lord, that was Binay Kumar Pradhan and others.
No. You are ଆପଣ ବର୍ତ୍ତମାନ ଲେଖୁଛନ୍ତି ଯେ you are the ex postal assistant Dhenkanal. You have already retired.
My lord.
And who are they? Those persons.
They are some of them retired and some of them are working.
Where is the post title of that WPC? And let us see the give a copy.
Yes.
Give a copy.
Yes,
so that this WPC is related to that way. Have you got a copy of that?
Not now. I will.
No, yes, give it. Okay, let's do. This writ petition has been filed by the petitioner Srikant Chandra Sundar Roy, was the ex-postal assistant Dhenkanal HO, with a plan for quashing the order dated 19/3/2019 passed by the Superintendent of Post Office Dhenkanal Division Dhenkanal. So also the order dated 25/9/2024 of the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 00535 of 2019 in dismissing the original application, so also miscellaneous application for condonation of delay. In the operative part of the order in paragraph 19, the London Tribunal inter alia observed that the facts and issues of the original application was similar to OA number 534 of 2019, and therefore there is no justification to differ from the view already taken in the aforesaid case. The London Counsel for the petitioner that against the order passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 534 of 2019, the petitioners, the applicants of the said OA challenge the order before this court in WPC number 10539 of 2024 and by order dated 34/2024, notice has been issued to the opposite parties, and this matter is required to be heard along with WPC number 10539 of 2024. However, the London Counsel for the petitioner is not having the copy of WPC number 10539 of 2024 with him to substantiate that it is against the order passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 534 of 2019, and it takes some time to file the copy of the writ petition and give a copy thereof to the London Central Government, London Deputy Solicitor General. Put up this matter.
At the earliest, my lord.
No, you have to say, you have to find out that WPC.
second week of
You
December.
are the counsel in that WC.
Yes, my lord.
Then there is no problem. It must be available in your office. So you can
Yes,
just
my lord.
give a copy so that we will verify.
Huh.
Place this matter in the week commencing from 9th December 2024. जी काउंसिल को ना दे चंदे ना सीजी सिंह को ना तो लिखी देवे है ना he filed a copy of the order passed in WPC number which is taken on record.
Yes.
Item 13.
May I please? May I please, sir? My lord, here I am challenging the order at Annexure 6 passed by the collector pursuant to a direction of this honorable court directing to consider my representation after a
Where is this court's earlier order?
My lord, it is there.
You have filed that?
Yes, my lord. Annexure 1.
Annexure 1.
My lord.
WPC 16485.
Yes, my lord. It was a representation disposal, my lord.
So direction was issued to the collector Puri to consider the representation.
My lord.
What order was passed thereafter?
My lord. That is the order at page 31.
Annexure 6.
21, sorry. Annexure 6. My lord, may I take your lordship to the relevant page 22.
This order you are challenging now?
My lord.
Annexure 6.
My lord. Lord, page 22. Para 2. Heard them. During course of hearing, the learned advocate for petitioner submits that Khata number 1016, plot number 2402, area acre 0.29 stands recorded in the name of irrigation department. Though kisam of land is recorded as kennel, in the field there is no kennel. There are plots. Their plots are both sides of the kennel. Since there is no kennel, the petitioner are in possession of their land, including the land acquired by the irrigation department. Now, my lord, the last paragraph. What the video says, a report was sought from the video. The video Kakadpur submitted the written statement stating therein that Khata number 106.
What is your prayer?
My lord, now my lord, what my prayer is, this land has not been used since the last 20 years. In view of section 101 of the Act, I have a right to return of the land. My lord, the section says if the land is not used for 5 years, the land is liable to be returned. Now, my lord.
Suppose your land has been acquired.
My lord.
And a part of it has been used, and for some years, let us say, it has not been used for the purpose for which it was acquired.
My lord.
You have also received compensation for
my lord. My lord, I have received compensation.
So the balance land is to be returned to you, even though the compensation amount has been paid by the government. That is your stand.
No, my lord. Okay. I bow down. That is apparent now from the submissions. But what the court records, what the collector records is that in fact that what they say is being used, it's a temporary asbestos house which has not been used from the government funds. So somebody has illegally constructed a house. I may take your lordship to that paragraph.
No, you come to after that your submission. You come to in the meantime.
In the meantime, my lord, in the meantime, Bhandagar Gram Panchayat has been newly created since the year 2017, being bifurcated from Lataharan Gram Panchayat. As per decision of Gram Panchayat, Khata number 101, plot number 1312, acre area 2.79 decimal government land is reserved for. This is not the land, my land. Is reserved for construction of Bhandagar Gram Panchayat office building. But local sarpanch with evil intention, without obtaining any work order from Kakadpur block, is going to construct Gram Panchayat office building over Khata number 1016, plot number 2402. This is my land. Acre 0.29 DC, recorded in the name of irrigation department. Now the petitioner requested not to construct the Bhandagar Gram Panchayat office building over the land. Now, my lord, the video Kakadpur submitted a written statement stating therein that Khata number 1016, plot number 2402, area acre 0.29 DC with Kisam land is recorded in the name of irrigation department, and an asbestos house as Bhandagar Gram Panchayat office building has been constructed over the plot number 2402 covering area 0.01 DC out of 0.29 DC. The plot number 2401, 2403 under Khata number 303 around the disputed land 2402 stands recorded in the name of Tamiz Khan, Layakat Khan, Atar Ali Khan, caste Muslim of Bhandagar village. The asbestos building over plot number 2402 is a temporary building and no funds have been sanctioned for construction of permanent Gram Panchayat building of Bhandagar GP. As per letter of SC Superintending Engineer Central Irrigation Circle Bhubaneswar, there is no possibility of renovation of water course there because of the roads and houses established around plot number 2402 and an area of acre 0.08 DEC out of 0.29 DEC may be handed over to the PR department for construction of Gram Panchayat building. The Sarpanch Bhandagar Gram Panchayat present submitted that Bhandagar Gram Panchayat has no its office building for which GP office temporarily constructed over plot number 2402 and the land may kindly be alienated for construction of permanent GP. What now the collector says, my lord, the next para. From the above discussion, it is revealed that Khata number 1016 plot number 2402 in Bhandagar Mauja was recorded in the name of petitioner, which was subsequently acquired by the state government for construction of canal, for which after the acquisition of the land is recorded in the name of Jalasachana Vibhag, but physically there is no canal at present for which petitioners are in possession as before, but the land is still recorded in the name of Jalasachana Vibhag. In this case, the petitioners have right title over the land in question. On the other hand, Bhandagar Gram Panchayat, newly created by way of bifurcation from Lataharan GP, is now functioning in an asbestos room constructed temporarily over the suit land. Since the suit land is recorded in the name of Jalasachana Vibhag, no alienation can be made unless relinquished by the said department. No requisition has also been filed by the BDO Kakatpur yet for construction of Bhandagar GP office building. Besides, no identification of government land for construction of Bhandagar GP office building is made yet by Revenue Administration. Before construction of GP office building over any government land, the alienation is required to be done following due procedure under OGLS Act and rules. But in this instant case, no such alienation of government land is still made in favor of PR and DW Panchayat Raj and Department for construction of Bhandagar Gram Panchayat office. Ask the BDO Kakatpur to file requisition in consultation with Tahsildar Kakatpur for alienation of suitable land, my lord, not this land. Suitable land for construction of Bhandagar Gram Panchayat. Now, my lord, what I was saying, the admitted case is it was acquired for the specific purpose for canal. Adjacent houses have all been their roads and buildings have been constructed. The only this plot, a temporary house was constructed illegally because no fund have been secured, no permission have been given. Now, my lord, what I say, because it is not used for the specific purpose for which it was acquired, and in the meantime, much more than 5 years have elapsed. In view of Section 101 and Section 24 of the Act, my lord, I am entitled to a return of the land. That is my A. And the collector himself records that, in fact, GP building has not been allowed to be continuing there, and it is a temporary structure somebody has constructed over that. And 0.01 DEC. My lord, and the learned collector himself records that all adjacent land, though were acquired, have all been constructed. Roads, buildings, everything has been constructed. Everyone is enjoying his land except me.
No. So, when that land was acquired?
99, my lord.
99. Which is that provision you said?
My lord,
101 of the
101.
New Act.
Return of
Right to fair compensation.
Yes. 101. वही सेमती पड़ेगी जो section provision section बाहर करी दो.
My lord, the land was acquired under the old act.
I will show that.
Now the petitioner seeking relief under the new act, which is not permissible.
My lord, I will justify. One zero.
101 provision.
Again, when any land acquired under this act remains unutilized for a period of 5 years from the date of taking over the possession, the same shall be returned to the original owner or owners or their legal heirs as the case may be, or to the land bank of the appropriate government by reversion in the manner as may be prescribed by the appropriate government. Now, my lord, section 24. Now, this deals it even if it is under 1894, the old act.
Just a minute.
My lord, I'm sorry. My lord, I skip A and 1A and B for a moment. I'll come back to it. Para 2, the subclause 2. Notwithstanding anything contained in subsection 1 in case of land acquisition proceeding initiated under Land Acquisition Act 1894, where an award under the said section has been made 5 years or more prior to the commencement of this act, but physical possession of the land has not been taken or compensation has not been paid, the said proceedings shall deem to have lapsed, and the appropriate government, if it so chooses, shall initiate proceeding of such land acquisition afresh in accordance with the provisions of this act. Now, my lord, if your lordship wants, I can take your lordship to 1. Subclause 1, notwithstanding anything contained in this act in case of land acquisition proceeding initiated under the LA Act 1895, where no award under section 11 of the said land acquisition act has been made, then all provisions of this act relating to determination of compensation shall apply. Where an award under said section 11 has been made, then such proceedings shall continue. So, my lord, 1A and B would not apply is my submission. My lord, subclause 2, notwithstanding anything contained in subsection 1, would apply. That's my submission, my lord. And here, the admitted
But
case
the
is,
physical possession of this land has not been taken,
my lord, here it is not taken in the collector's. My lord,
or the compensation has not been paid.
or
But you have been paid the compensation.
I have been paid, my lord. Question of return of land will only come when once it is acquired and compensation has been paid. This is or,
but where the physical possession has not been taken,
or
the compensation has not been paid.
So, or, my lord, either this or that. That's my understanding of the. Had it been and,
So you examine it, huh?
And what about the old law and new law that speaks about that?
That is. Listen, the writ petition has been filed by the petitioner for quashing the order dated 25/9/2024 passed by the collector Puri, bracket opposite party number 2. A further prayer to return the land under khata number so and so to the petitioner under section 101 of this 2013 Act, Purata Lekwe, hereafter 2013 Act. It is the case of the petitioners that the aforesaid land, which originally belonged to the family of the petitioners, and it was acquired by the Irrigation Department, Government of Orissa, for the construction of canal over the same. In spite of acquisition long back, the same was never used for the purpose for which it was acquired, and the most of the land originally belonged to the petitioner is lying vacant. It is further stated that though the irrigation department had acquired various adjacent plots of the co-villagers of the petitioner, but owing to the non-use of the acquired land for a very long time, the adjacent plot owners are using the acquired lands and have constructed building over the same. They stated that due to paucity of fund, the petitioner were not able to construct the building over the same. And taking advantage of the same, the Sarpanch Bandhagarh Gram Panchayat started to construct a temporary Panchayat building over the land. For which the petitioners approached the opposite party number 2 and 3 to restrain the opposite party number 4, Sarpanch Bhandagar Gram Panchayat, from making construction over the land of the petitioner, which was recorded as NR. The Land Council submits that due to inaction of the opposite party number 2 in deciding the representation of the petitioners, they approached this court earlier in WPC number 16485 of 2021, and in pursuance of the order passed by this court on 2/6/2021, the opposite party number 2 has passed the impugned order on 25/9/2024, wherein the representation filed by the petitioners was rejected, and further the direction was issued to the BDO Kakodpur to file requisition in consultation with the Tahsildar Kakodpur for allocation of a suitable government land for construction of Bhandagar Gram Panchayat office building. The Land Council for the petitioner placed section 101 of 2013 Act, which says that when any land acquired under the 2013 Act remains unutilized for a period of 5 years from the date of taking over the possession, the same shall be returned to the original owner or owners or their legal heirs, as the case may be. He further placed, which is that other section
24,
section 24 of the said Act,
subclause 2,
in which subsection 2, it has been stated that in case the land acquisition proceeding initiated under the Land Acquisition Act 1894, where an award under section 11 has been made 5 years or more prior to the commencement of Act, but physical possession of the land has not been taken or compensation has not been paid, the said proceeding shall be deemed to have elapsed, and the appropriate government, if it chooses, initiate the proceedings of such land acquisition afresh in accordance with the provisions of this Act. The Land Council for the petitioner submits that admittedly, the land, the physical possession, the land has not used for the purpose for which it has been taken, and other co-villagers who are the adjacent landowners are using the same. Therefore, the collector Puri should not have rejected the representation of the petitioner. Stop. The London Council for the State submitted that since the land was acquired under the old act, that is Land Acquisition Act 1894, the provision under section 101 of 2013 Act is not applicable. Section 24, the Land Council for the petitioner placed section 24 of this one. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Place this matter in the week commencing 4 weeks after. Counter affidavit. The London Council for the State accepts notice for all the opposite parties. Extra copies of the writ petition be filed, and matter be listed. So on so. Counter affidavit, if any, be filed in the meantime, giving copies to the London Council for this. Yes.
Item 14.
My lords, in this case, caveat is there, and I have sought a copy of the caveat petition. Yesterday only I have sought, because earlier I was not aware of caveat. So
you have not received the copy?
Yes. Yesterday I have received the copy.
So what do you say now?
So if my learned friend want to take time for filing the counter,
Let them argue the matter, my lord. Let them argue the petitioner, argue the matter.
Yes.
Whether admitted or not.
the caveat petition itself, sorry, my lord, caveat petition, as I understand, without
You
hearing him,
you have already entered appearance.
My lord.
That means
and without hearing him, no order can.
so you are entitled to file the objection.
Right.
So if you say that no, I don't want to file any objection, matter is something different. But
My lord.
that is why he's saying that you are
File the objection 4 weeks time to grant me.
why this WPC has been filed by the bank, Mr.
WPC.
Yes.
Oh, sorry,
yes.
this is against the order of the DR80 Kolkata, my lord.
DR80, what order has been passed?
The order was, my lords, the main.
Where is that order?
Order is page number 192, my lords.
192.
192. But the main case is.
In the DR80, you are the respondents.
Yes.
We are the respondents.
Okay.
In fact, my lords, I am for the bank. The essay was filed by the borrower before the DRT Cuttack. So it was dismissed. Thereafter, the borrower referred an appeal before DRT
Right.
Kolkata. DRT Kolkata set
Decided.
aside the order of DRT, my lords.
Okay. So no, this is the order.
My lord, this
Nothing
is
has been mentioned here.
my lords, 192.
Gote paragraph.
First, system it starts from 193. The main case, my lord, the point of law is concerned, my lord. The learned DRT has made out a new case, which was no one's case, my lords. In the sense, he has interpreted.
What is the stage when they challenge that before the
sale certificate has been issued, registered?
Then Bafna case is.
Yes, my lord, Bafna
He has
case.
dealt with probably. DRT has dealt with Bafna.
dealt and misinterpreted the law and also the judgment of the Honorable Supreme Court, saying that there should be a gap of 30 days between between the notice of Rule 8.6 and Rule 9.1. That is nobody's case. In fact, the rule is also does not prescribe that 30 days notice gap period between Rule 8.6 and Rule 9.1. That is the only case. That is the only case whether that can be interpreted in that way.
Petitioners, Bank of Baroda, has filed this writ petition challenging the order dated 6/8/2024 passed by the London DRT Kolkata in appeal number 4 of 2023. And to uphold the order dated 16/4/2019 passed by the London DRT Cuttack in essay number 69 of 2018. As it appears, the opposite party number essayটা কি ফাইল করছিলে এই যে অপোজিট পার্টি অଛନ୍ତି তাদের কি 2 MRP Group of Industries opposite party number 2 MRP Group of Industries filed essay number such and such ଯୋଉଟା essayଟା ଦିଆ ହେଇଥିଲା before the London DRT challenging what order you were challenging? What is the order of the DRT?
DRT is at my lords.
Have you filed that order?
My lord.
Fine.
Page 1. Annexure 3 months.
Annexure 3.
My lords. At page
135.
Acha. Filed for setting aside the orders passed in bank miscase number 56 of 2015 in the proceeding under section initiated under section 14 of the Surface Act. So also for setting aside the notices issued by the bank under section 13.2 and 13.4 of the Surface Act and the later dated 2/1/2018 under Annexure 7. The London DRT Quarter by order dated 16/4/2019 has been pleased to hold dismiss the essay and directed say operative portion টা লিখে দেবে page number 148 ওটা না challenging such order the opposite party number 2 approached the London DRT and was passed the impugned order dated impugned order টা কেটে কইলে
14/8/2020.
না না annexure টা কেটে
My lords, Annexure 6.
DRT
DRT, my lords, Annexure 6.
6
My lords.
Mr. Niyamati London Council appearing for the petitioner submitted that the London DRT has not properly followed the decision rendered by the Honorable Supreme Court in case of Celir LLP versus Bapna Motors Mumbai Private Limited reported in 2024 to SCC 1 and set aside the order passed by the London DRT. So also the e-auction sale conducted on 2/2/2018 and directing the bank to refund the sale proceeds to the auction purchaser. This auction purchaser was made a party before that.
Yes.
Has he challenged this order before this court?
No. I am no notice we have received.
Since the opposite party number 2 has already entered an appearance by filing a caveat petition, and copy of the writ petition has also been served on him. Stop. NI command. And there are other opposite parties.
So the contesting is only 2 and 6 minors. Others were, because they were made parties there,
Issue notice
to
on the
6 only.
question of admission, indicating therein that the matter shall be disposed of at the stage of admission. There is no necessity to issue notice to opposite party number 1. The Land Council for the state accepts notice for opposite parties number 3 to 5. Extra copies of the writ petition be served. Mr. Naik, accept notice for the collector, sub-register, and DCP Bhubaneswar. So far as the private opposite party number 6 is concerned, requisites for issuance of notice, a speed post with proof of delivery shall be filed. He is that auction purchaser, no? Okay. Requisites will be filed within a week, and the matter will be placed such and such date. Counter affidavit, if any, be filed in the meantime. Yes. What is your interim prayer?
It's order of
the operation of
Operation
the
of-
order passed by the London DR80 dated so and so shall remain state until further orders. Yes.
apply.
Item 15.
My lord, before approaching your lordship in this writ petition, my lord, the petitioner had earlier filed an writ petition. I have annexed that, annexure 2, page 15, WPC number 13098 of 2024. In
place that order.
My lord, your lordship may kindly come to relevant page is 17, page 17.
Yes.
Now that order, this matter is had Mr. Counsel, London Counsel for the petition and London Counsel for the opposite party bank, Mr. Udgata, London Counsel for the opposite party bank, at the outset, on instruction, fairly submits that inadvertently the order passed in the earlier writ petition has somehow missed the site and not followed, and the subsequent notice for auction of the secured asset has been published. In view of the same, he on instruction submits that the said auction notice shall be withdrawn at the earliest. Keeping in view the above submission, we disposed of the writ petition with the observation that the petitioners would be clearing the outstanding loan dues within a period of 4 months. Hence, and till then, the opposite party bank will not take any coercive measure in respect of the said property. It is further observed that on failure of the petitioners, the opposite party bank would be at liberty to take appropriate action in accordance with law. My lord, pursuant to this direction, my lord, I have deposited within that 4 months, I have deposited the outstanding loan amount of rupees 9,22,000 some odd. My lord. That your lordship may kindly turn to page 20 of the writ petition, my lord, that I have annexed the copy of the bank drafts. But after paying this, my lord, I asked the bank to supply me the NOC, my lord, annexure 3, page 19. They have written, your lordship, my lord, that is
amount
my lord, total 9,22,000. My lord. My lord, after depositing that amount, my lord, the bank has endorsed in my application, annexure 3, page 19. Your lordship may kindly see. The last, towards the bottom of that page, received the demand draft number such and such dated 10
is this and this per
My lord,
this,
in terms of the High Court order dated 21/5/24, they have admitted, and thereafter, my lord, what they did, my lord, they have issued a letter under annexure 1, page 14, asking me to pay the interest amount for that 4 months, which was allowed by this honorable court after considering my case, my lord. For that intervening period, they have charged interest. And along with that, my lord, you'll also kindly find page 14 document, my lord. towards the last part, paragraph 4, my lord. Kindly note that it starts from kindly note that, your lordship. Due to delay on your part in repayment, the further interest in intervening period, May, June, July, August, and September, that four months period, my lord, had been applied in the loan account, which is still unpaid. In our auction sale notice dated 26/4/24, the outstanding loan with interest as on 26/4/24 was informed. As on today, 4/10/24, the loan amount outstanding with interest is rupees 71,506.21 rupees. Further, the cost and charges are still unpaid in the loan account. The following are the details of the same as on 4/10. Your lordship, kindly see this note. Latest till 4/10/24 is 71,506.21. Legal expenses for read petitions debited to bank, GL and DRT suit interest 69,000 for their lawyers, my lord.
Yes, Mr.
I will pay.
Data.
Yes.
This is the conduct of.
ରିପୋର୍ଟ କରିଥାଉ ସମୟ ଦେଲେ 4 ମାସ ଭିତରେ ପଇସା ଦିଅନ୍ତୁ ସେ ଦେଇଦେଲେ ଆପଣ ରିସିଭ କରିଦେଲେ ଯେ ଇଟ୍ ଇଜ ଇନ୍ ଟର୍ମସ୍ ଅଫ ଦିସ୍ ୱାନ୍ ସୋ ପୁଣି ଗୋଟେ କଣ ଆସିଥିବେ ନା ଆଡଭୋକେଟ୍ସ କୁ କନସଲ୍ଟ କରିଥିବେ ସିଏ କେମିତି ଆପଣ ଏମିତି ଓପିନିଅନ ସବୁ କିଏ ଦଉଛନ୍ତି
Your lordship, just have a glance, my lords.
ପରେ ବି ଆହୁରି ଚାର୍ଜ କରୁଛନ୍ତି
Just have a glance, my lords.
Terrorism,
After the
machinery, file.
order by this honorable court, we have given this letter wherein the amount reflected as outstanding 9,46,318 millers. He has not annexed that particular letter, millers.
No. He has paid as he said. The bank
As per the direction.
Your lordship, just have a glance, millers. The order of this honorable court says that millers, he has to clear the entire loan outstanding, millers. The loan outstanding is
the order of this court is very clear
millers.
That what time was also granted, that is there, right? So the time that is granted is 4 months.
Millers.
है ना? एवं outstanding loan dues जहाँ थी वो तब clear करिए. So outstanding loan dues according to the petitioner was 9 lakhs and all. And that he deposited, and your officer has received the demand draft that you are not disputing. So if you say that yes, as on that day, some more amount was there, not leave that interest, that the advocate ye charges, ତାକୁ ଛାଡ଼ି ଦେଇକି ଯଦି ଯେତେବେଳେ order pass ହେଲା ସେତେବେଳେ ଯଦି ଆଉ କିଛି outstanding dues ଥିଲା ତାହେଲେ କୁହନ୍ତୁ that is true. ସେଟା କେତେ ଥିଲା?
9,46,000 millers.
In addition to this 9 lakhs.
No, millers.
Total thila
total 9,46,000. 9,22,000 he has paid.
How 20?
My lord, may kindly see the document. Document.
This particular letter, millers.
Document, your lordship, may kindly see. Page 19, annexure 3. That application was made by me to the bank, indicating, your lordship, may kindly see. I am writing to inform you that I am depositing to demand draft number such and such, totaling 9,22,513 drawn on SDFC Bank payable at cutoff. This payment is towards the outstanding loan amount of 9,22,512 for Saraswati Bricks as per your auction notice number such and such dated 26/4/2024. They have issued their own letter. Now they are disputing the amount.
26/4 ରେ
ସେ ଆଜ୍ଞା ଦେଇଥିଲେ 9 ଲକ୍ଷ
ତାକୁ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କଲେ ଏବଂ
ଆଜ୍ଞା
ସେ ଆମାଉଣ୍ଟ ଟା ଯେତିକି ରିଫ୍ଲେକ୍ଟ ଥିଲା ତାକୁ ସେ ଆମାଉଣ୍ଟ ଡିମାଣ୍ଡ ଡ୍ରାଫ୍ଟ.
Yes, my lord. Now they are coming up with another plea that such and such amount.
ଆପଣ ଅବିକା ପାସ୍ କରିଦବା ନା ଆପଣ କଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ ଆପଣଙ୍କର ଅଛି କିଛି ସିଷ୍ଟମ ଆପିୟରାନ୍ସ ରେ ଗୋଟେ ତାପରେ ଆଉ କଣ ଏକ୍ସଟ୍ରା ଥିବ ଯଦି କଣ?
These are 13/7 millers.
13/7
of the sufficient millers.
देखिए कौन 13/7.
The auction notice says millers that amount plus interest and cost millers. But he is only millers saying about only that amount millers.
How many matters of your bank is being listed today in this pre-Lok Adalat, Canada Bank, have you got any idea? Canada Bank corporate କରୁଛନ୍ତି ଆପଣ settlement କରିବାର
ଆଜ୍ଞା
ଆଜି କେତେଟା matter history ଜାଣିନାହାନ୍ତି
କେତେ କହୁଛନ୍ତି?
minutes 13 minutes surface said
Let them deduct that interest part for 4 months and other demands they have raised regarding the lawyer fees and other things.
interest ଛାଡ଼ନ୍ତୁ ଆଉ ବାକି ଯୋଉ ଟଙ୍କାଟା
ଆଜ୍ଞା
କହୁଛନ୍ତି
ସେ କୁହନ୍ତୁ କେତେ ନେବେ
security interest.
it's subsection saying where any action has been taken against a borrower under the provisions of subsection 4, all costs, charges, and expenses which, in the opinion of the secured creditor, have been properly incurred by him or any expenses incidental thereto, shall be recoverable from the borrower, and the money which is received by the secured creditor
this
shall.
This was not permitted by this court in view of the earlier order. This order stands now. You have not challenged the order before the Honorable Supreme Court.
Yes.
So when 13.7 was there,
Yes.
so you have not made any submission at that point of time. Sir, apart from the so we are also entitled to get. So please pass the direction. So this court said that only the outstanding dues is to be so.
Exactly.
So that is how you have to receive the amount.
Exactly. Loan outstanding means plus the outstanding plus further interest and cost. That is my.
They have acknowledged the receipt was acknowledged by the bank.
And they
And
are
also
also saying that they are ready to pay the cost only.
Land Council for the state. This writ petition has been filed by petitioners Messrs. Shashwat Briggs and Srimati Chagali Avha, challenging the later dated 4/10/2024 of the opposite party number 1. Opposite parties further. In which the opposite parties raised a demand of rupees 1,47,655 from the petitioners. The Land Council for the petitioner submitted that earlier the petitioners approached this court in WPC number 13098 of 2024 challenging the auction notice and when the matter was taken up on 21/5/2024, the Land Council for the bank made a submission that the earlier order passed by this court in the another writ petition was inadvertently not taken into account and therefore the auction notice shall be withdrawn. Accordingly, this court on the submission of the Land Council for the bank disposed of the writ petition with observation that the petitioner would be clearing the outstanding loan dues within a period of 4 months, and till that day the bank shall not take any coercive measure in respect of the property. It was further observed that on the failure by the petitioners, the bank would be at liberty to take action in accordance with law. The Land Council for the petitioner submitted that the outstanding loan amount against the petitioner was 9,22,512.21 paisa, which would be evident from the auction notice dated 26/4/2024, which was challenged in the earlier petition filed by the petitioners in WPC number 13098 of 2024. Stop. After the order was passed by this court on 21/5/2024, the petitioners deposited two demand drafts, one of rupees 3,46,903 and the other was of 5,75,610. And both the demand drafts were received by the manager, and it is mentioned in Annexure 3 that it was in terms of this court's order dated 21/5/2024, passed in WPC number 13098 of 2024. Stop. The Land Council petitioner further submits that strangely on 4/10 the bank sent another notice in the input later, issued the input later on 4/10/2024, demanding rupees 1,47,655, adding the
interest for 4 months.
Interest for 4 months
Besides litigation.
Besides the legal expenses and
insurance,
And insurance.
plant and machinery,
He used
fine,
to pay me that time
terrorism,
because that mirror's
the
stocks have
government.
been insured.
insurance, etc. And stock, which is not permissible in law. However, the Learning Council for the bank, Mr. Gata, pointed out section 13(7) of the Surface Act, which reads as follows. When the adverting to the contention raised by the Land Council for the respective parties, we are of the view that when the matter was earlier before this court in WPC number 13098 of 2024, and the Land Council for the bank was heard, no objection was raised, no submission was made that apart from by the London Council for the bank, that apart from the outstanding dues, the petitioners may also be asked to deposit the legal expenses, etc. Therefore, this court order and this court's order dated so and so has also not been challenged before the Honorable Supreme Court, which has attended finality. Therefore, when the petitioner, in terms of the aforesaid order dated 21/5/2024, deposited the outstanding loan amount as per the auction sale notice within the period stipulated by this court, we are of the view that the further demand of rupees 1,47,655 as per letter dated 4/10/2024 is not sustainable in the eye of law. Same is hereby set aside. Writ petition is allowed. Yes.
With permission, with permission,
Yes.
Your Lordship, just a glance. Really, we have paid the insurance money, for him.
You pay what money pays.
Item 16.
Lordship, my limited prayer in the repetition is that I have filed one OTF proposal before the bank authority had annexed 3, Your Lordship. That has not yet been considered and auction notice was issued. For that reason, I...
3 to be disposed of. Auction sale notice.
Yes,
Then you have to approach the
26th.
auction sale surface matter. He has to approve the alternative. Yes, disposed of.
Item 17.
by name maybe.
Name, अच्छा ये review to नाम ना सुनो ये who method directed?
It has
16 branch manager bank of India.
9 sector. Yes.
Item 17. May I please, Your Lordship? My Lord, the petitioner approached this Honorable Court earlier, challenging the possession notice under Annexure 1 and 2, and by virtue of Your Lordship's observation under Annexure 4, the petitioner approached the DRT by filing original application. My Lord, the petitioner also filed an application for condonation of a delay, but the Lord DRT dismissed the condonation petition as well as the OA. Again, the petitioner approached this Honorable Court, and this Honorable Court, by the order under Annexure 7, directed to approach the appellate authority. Well, the petitioner filed the appeal. In the meantime, the appeal has been entertained and the delay has been condoned. The appropriate application for appropriate order for stay is pending consideration since the opposite party taken time to file a reply, my Lord. My Lord, in the meantime, the my instruction is that the PO is on leave and the matter is adjourned to my Lord 9th December 2024, my Lord. In the meantime, the opposite party, with the help of recovery agent and the local policy, by virtue of order under Annexure 2, passed under Section 14 of the Act, came to the suit land and threatened to dispossess the petitioner, my Lord.
Said that the matter is sub judice.
Sub judice before the appellate authority.
Why are you not making in
my Lord, because of,
before that court?
my Lord, my submission is the PO is on leave. That is why I could not move there.
Where is the document to that?
My Lord,
where is the order?
my Lord, I on instruction I am submitting only for that relief since the OA.
When you file the interim application, when you press
my Lord, Annexure 8, my Lord.
Annexure 8.
Annexure 8 series, my Lord.
No,
Annexure 8, my Lord.
Is the order.
Interim order.
My Lord, interim order.
Interim petition.
Interim petition. My Lord, my Lord, kindly see page 31. 31. Page 31.
Okay, that is your
delay condone
application.
My Lord, condone. Then, my Lord, page 32. Page 30.
Then the IA for so pass appropriate order application shall be considered and disposed of after hearing the Learned Council at the time of final hearing.
My Lord.
Then IA so application filed, no objection filed by the respondent bank. Learned Council for the respondent pays for and is granted 1 week time. So this was supposed to be listed on 31st July 2020.
My Lord, thereafter, my Lord, the matter was listed for taken up the petition for waive out the statutory deposit. Page 33.
Order kind.
My Lord, 33 रे order अछि तापरे appropriate order टा ए पर्यंत हेई पारिन
नहीं 31 जुलाई 2024 अरे मैटर प्लेस हेइथिला
my Lord.
जदी पीओ ऑन लीव थांते
now on leave my Lord.
तापर कोन ऑर्डर है नाम केम जान
my Lord, तापर order हेछि I 43 रे entire order sheet टा मु annex करि पारनी.
My Lord, I am appearing for bank. I have instructions. Pursuant to your Lordship's direction in the second writ application, the DRAT matter is pending. What happens, my Lord, I appear always in the DRAT. When a borrower goes up in appeal, there is a petition which has to be decided first by the DRAT. That is waiver of normally section 18 50% dabo. Maximum 25% so that waiver petition is pending
for
so unless that waiver is allowed, then the appeal cannot be given a number. It stays at diary number. तापरे आगे stay का consider करा जाए. I regularly appear.
बर्तमान pending अछि 43.
He has approached this honorable court कि आमे surface रे ଯାଉଛୁ section 14 ରେ
thereafter my lord the peon leave
So
that
let
is
him-
adjourned to 9/12/2024
ବର୍ତ୍ତମାନ ଆପଣ ଡିପୋଜିଟ୍ କରିଦିଅନ୍ତୁ ଯାହା କି ରେଗୁଲାରାଇଜ କରିଦିଅନ୍ତୁ ସେଠି ଆପଣଙ୍କର ଇଣ୍ଟରିମ୍ ଆପ୍ଲିକେସନ
well till 9/12/2024 the matter is taken up from
how many
otherwise my appeal will be infructuous
in your writ petition
yes
that there is no other alternative efficacious remedy available for which you have availed the extraordinary
yes yes my lord
not only it is available but you will also avail the same
yes my
so ethi ame writ petition ta kemti entertain
my lord only since 9/12/2024 is pending for consideration till I move the appropriate application there
My lord,
otherwise
he will,
my
by coming here,
will be infructuous
he will short circuit the DRAT, my lord, because that is a statutory
writ
format.
petition has been filed by the petitioner Messrs. Sapna Builders and Suppliers challenging with a prayer for a direction to the opposite parties not to take any drastic step to dispossess the petitioner from the properties and oblique or to maintain status quo in issue till the appellate court consider and dispose of the application. Learning counsel for the petitioner submitted that the petitioner approached DRT order ta kahin
DRT order annexure 5 my lord page 22
annexure 5
my lord page 22
acha the petitioner approached the DRT cutter learning DRT cutter in SA number 2 ଯେ 835 ତ
my lord
SA ଗୋଟେ ତା ପରେ କଣ ଗୋଟେ NW ଲେଖା ହେଇଛି କଣ
ସେଟା ବି ସେଇ ଡାଇରୀ ନମ୍ବର ରେ ଥିଲା IA ନମ୍ବର IA ଟା ଡିସ୍ପୋଜ
835/2023
ଗୋଟେ NDN କାହିଁ ଅଛି କି ଆଜ୍ଞା ସେ ଡିଲେ ଟାକୁ ଯଦି ସେ କଣ୍ଡୋନ ନ କରଲେ till delay is not condoned that NDN ଡାଇରୀ ନମ୍ବର ରହେ ଯଦି ଡିଲେ କଣ୍ଡୋନ କରିଦେଲେ ତାହେଲେ ଆଜ୍ଞା SA ନମ୍ବରଟା ଆସିବ ସେଥିପାଇଁ NDN may be reflected in my lord's order sheet
ଆଚ୍ଛା ଓକେ SLC
along with the IA
ସେଠିକି ସେଟା ଲେଖିବେ and since there was delay in filing the SA the Learning Tribunal found no and the Learning Tribunal found no sufficient cause for condoning the delay. The IN number 1367 of 2023, which was filed for condonation of delay, was dismissed. So also NDN number 835 of 2023. Challenging the order of the Learning DRT, the petitioner approached the Learning DRAT in misappeal DY number 34 of 2024.
84.
Sorry, 84 of 2024. It appears that for filing the appeal, also there was delay of 19 days for which an application was filed for condonation of delay and by IN number 42 of 2024 and the Learning DRAT has been pleased to condone the delay in filing the appeal. However, so far as the other application,
my lord application for waiver of pre-deposit under section 18
the application for the waiver application by IN number 43 of 2024 so also IN number 112 for 2024 filed by the appellant for appropriate order that was kept for consideration and the date was fixed to 31/7/2024. The Learning Counsel for the petitioner submits that till date the interim applications filed by the appellant have not been heard and the presiding officer is on leave and the matter
chairperson appellate
chairperson appellate tribunal is on leave and the matter the date is fixed to 9th of December 2024 and taking advantage of the same the bank is trying to dispossess the petitioner from the property Land Council for the bank, on the other hand, submitted that till the petitioner deposit the amount as for law, the appeal is not maintainable, and
And no interim order can be passed also.
no interim order can be passed. And till date, he has instruction that the petitioner has not deposited the amount, and stop. Be that as it may, since the petitioner has already approached the availed the alternative remedy and his appeal is sub judice before the London DRAT, and the prayer made in this writ petition can also be considered by the London DRAT in accordance with law. We are not inclined to entertain this writ petition, which is accordingly dismissed.
My name, Mr. Subrat Mishra, may kindly
Subrat Mishra, Land Council
for
appealing for the opposite party. ସମସ୍ତଙ୍କ ପାଇଁ ଆପଣ appeal କରୁଛନ୍ତି
ଦେଇନାହାନ୍ତି ଷ୍ଟେଟ୍ ବ୍ୟାଙ୍କ ପାଇଁ ଆଜ୍ଞା ଖାଲି ମୁଁ ଅଛି
ଦିଅନ୍ତୁ ଗୋଟେ କପି ଦେଇଦିଅନ୍ତୁ
କପି ଗୋଟେ ଦେଇଦେବେ ଷ୍ଟେଟ୍ ବ୍ୟାଙ୍କ ଅଫ ଇଣ୍ଡିଆ ପାଇଁ
1 and 2.
1 and 2
1 and 2
obliged my lord
Bank of India na କୋଉଟା
State Bank of India ଆଜ୍ଞା OP 1 and 2
That is 17.
17
17 time
କୋଉଟା କଣ ହେଲା
ସେ ଯୋଉ ଇଏ ଥିଲେ ଗୁରୁ ଥିଲେ ନା କର
yes next
May I please, Your Lordship? Your Lordship, in this matter, the petitioner has a very limited prayer to regularize her account, Your Lordship. And for the same, she has already approached the bank by paying the overdue amount. Annexure 5 is pending, Your Lordship, before the opposite party bank.
the notice has already been issued.
As instruction received, sale has been made and certificate has been received.
The Learning Council appearing for the bank submits that sale certificate has already been issued. In view of such submission, we are not inclined to entertain this writ petition. In view of the decision of the seller LLP versus Bapna, the petitioner is at liberty to approach the alternative. I feel like the petitioner's prayer is this. Hello? Council, please.
Under section 70.
Obliged. Item 19.
The petitioner has taken only 3 lakh rupees loan from the bank in 1997, and now the bank is claiming and all the amount has been recovered by the bank. Only 35,000 has been outstanding by the petitioner. Notice of Annexure 2, page number 19 and page number 20.
So approach of the alternative
my humble submission is that before issuing this notice, the
ଯାହା କହିବା କଥା ସେଠି କହିବେ possession challenge କରିଛନ୍ତି ଆଉ ଏତିକି ମୁଁ ଦେବି କଣ କରିବେ ଯାହା କହିବା କଥା ସେଇ କହିବେ
already ଆମକୁ ଗୋଟେ order ହେଇଥିଲା ଅଣ୍ଡରଲୁ ହାଇକୋର୍ଟଙ୍କର ଆମେ ତାଙ୍କର ପୁରୁଣା
ଆପଣ ଯାଆନ୍ତୁ DRT କୁହନ୍ତୁ ଯାହା କହିବା କଥା yes next
Item 20.
Orissa government land settlement matter Millard. Representation pending Millard. Similar order may be passed Millard. Item 20 and 21 Millard.
ଯୋଉ annexure number ସବୁ ଠିକ ଅଛି
Annexure 3.
Item 22.
I am appearing, my lord. Criminal appeal number 391 of 2049.
The Lordship had called for a report from the police as to whether they misused their liberty granted.
By virtue of the order dated, my lord, 39/2024. After being released on bail, the conduct of the present appellant.
Arata didi. Bicha. They don't know.
Serial number 465 of 2014. It is Mr. Das. It is your matter.
Yes, ma'am.
Poppu alias Kishore Kumar Sahu.
Yes, ma'am.
How many appellants are there in that?
Two appellants, ma'am.
No. So far as your appeal is concerned, one appellant.
One appellant.
You have been released on interim bail.
In my lord, time to time.
File order dated last order.
Last order, let's see. Last order, my lord. She surrendered on 23rd July.
Last order is 21/5/2024. 21/5 ରେ ଆପଣ 2 ମାସ ଯାଇଥିଲେ।
Yes, ma'am.
ତା ପୂର୍ବରୁ ମଧ୍ୟ ଆହୁରି ଯାଇଥିଲେ।
Yes, ma'am.
ଓକେ। ଠିକ ସମୟରେ ସରେଣ୍ଡର କଲେ।
Yes, ma'am. Lastly, surrender 23rd July 2024, ma'am. After expiry of interim bail, we have filed the surrender certificate.
ଗଣ୍ଡଗୋଳ କରିନାହାନ୍ତି କାହିଁ ରିପୋର୍ଟ କାହିଁ ଅଛି? ଆଗେ ଏଇଟା ଦିଅନ୍ତୁ ସେ ଯୋଉ ସେ ପପୁ ଆଲିଆସ କିଶୋର କୁମାର ସାହୁ। ଏଟା ଗୋଟେ ଆଉ ଗୋଟେ କେସ୍ ଅଛି ଆପଣମାନେ ଆଉ ଯୋଉଟେ କେସ୍ ଏଗୁଡା ସବୁ ପୁରୁଣା କେସ୍ 2002-03
Very stale case, ma'am. That has been already been disposed of. My instruction was to.
ଡିସ୍ପୋଜ ଅଫ୍ ଆଣିକି ଦଉନାହାନ୍ତି ତାଙ୍କୁ ଇଣ୍ଟରିମ୍ କଣ ଭାଉଲେଟ୍ କରିନି। ଟୋଟାଲ ଆପଣ କେତେ ବର୍ଷ ରହିଲେଣି?
23rd 7 2024, ma'am. On the day of our judgment, ma'am. Prior to that, he was on
ପ୍ରଥମରୁ ଆପଣ ଟୋଟାଲ ଆପଣଙ୍କର କଷ୍ଟଡି ପିରିୟଡ କେତେ?
the period, my lord. From 23rd 7 2014, prior to that, he was inside custody.
କାରଣ ଏଇ ଆପିଲଟା ତ ହଉଛି 2014 ନା? ତା ପୂର୍ବରୁ ଆପଣ ଟ୍ରାଏଲ ବେଳେ ବେଲରେ ଥିଲେ?
He was on bail, ma'am.
Acha, he was on bail. Thereafter, since 2014, you have on number of occasions you have gone on interim bail or what you say?
Yes, ma'am.
Sir, interim bail le jayichanti ha.
He was released on interim bail on 13/5/2024, my lord. Again 21st/9/2024, my lord. Again 18/3/2016, my lord. Again 27/4/2016, my lord.
First order pass ହେଲା ଏଇ କୋର୍ଟରେ ରିଜେକ୍ଟ ହେଲା ଆପଣଙ୍କର 9/1/2015 ରେ। ତାପରେ
Released on interim bail 21st/9/2015.
21st?
Yes, ma'am. 21/9/2015.
21/9/2015 अच्छा देखियो। फास्ट ऑर्डर ला 21/9/2015 ଏଟା ଆପଣଙ୍କର ମାଙ୍କ ଦେହ ଖରାପ ଥିଲା। ତାପରେ
subject to verification by London State Council. Thereafter 18/3/2016.
ହଁ ଠିକ କହିଛନ୍ତି 18/3/2016। ତାପରେ
27/4/2016.
24/7.
Yes, ma'am. 27/4/2016.
27/4/2016, right.
ତାପରେ ହଜୁରୁ 12/9/2016.
12/9/2016, right.
Thereafter, my lord, 27/7/2018.
27/7/2018 ନାଇଁ ସେଟା ହଉଛି 25/7/2018। 25/7 2018 তারপরে
Thereafter, my lord, your lordship has pleased to relieve on bail on 21st 5 2024, subject to verification by lord. 21st 5 2024 in IN number 2014 of 2020.
এটা হচ্ছে লেটেস্টটা 21/5/2024
He, after expiry of interim bail, he surrendered before the court below, my lord, on 23rd July 2024. And during enjoyment of that interim liberty, conduct of the present appellant was very orderly and excellent. He never misused, he said.
Mr. Devasnan Das, Learned Counsel, appearing through virtual high court. Kodi jaigandi?
My lord, Jajpur.
Jajpur. Submits that during pendency of the appeal, the petitioner has been granted interim bail as per the orders dated the order from the and he has never misutilized the liberty while on interim bail and surrendered at the right time. Yeah. As per the previous order, the Learned Counsel for the state has produced the written instruction received from IIC Purighat Police Station, which indicates that during interim bail period, the petitioner has not violated any term and condition of the bail. The written instruction is taken on record. After hearing the Learned Counsel for the respective parties, the conduct of the petitioner during the interim bail period, and since no chance of early hearing, we are inclined to release the petitioner on interim bail for 3 months. IA is disposed of कर देवे, our date fix up कर देवे. He has to file the surrender certificate.
Mr. Das, the visibility and sound is all right from your cabin?
Yes, ma'am.
All right.
Yes, ma'am.
No, we are able to hear you perfectly.
Yes, ma'am. I am also able to hear my thoughts.
କେତେଟା arrangement ସେଇ type ର ହେଇଛି ନା ଗୋଟିଏ ମାତ୍ର?
No one.
And then there are one arrangement is there.
One. Everywhere.
Staff of the High Court have been withdrawn and staff of the district are cooperating.
Okay. Yes.
I am in 391, criminal appeal number 391. He was given interim.
ତାଙ୍କର ଇଏଟା କାହିଁ ସେ ଯୋଉ not in the ଆପଣ ବି ସେମିତି ଯାଇ
12 ବର୍ଷ 3 ଥର IM number 1894 of 22
ତାଙ୍କର କଥା ଦେଖିକିନି ଏ ଯୋଉ CRL 391 of 2014 ଏଇ order ସେ ଯୋଉ interim bail ଯାଇଥିଲେ ଲେଖିଲେ ବି bail ଯାଇଥିଲେ ତାପରେ report ଏଇଆ ହେଲା ତେଣୁ ସେ 3 ମାସ ହେଲା। Yeah.
Item 23.
Was pleased to allow the petitioner to go on interim bail for 3 months. He was released on bail, but surrender certificate could not able to get.
Original na nahi.
What is instruction nahi? माने भोट कॉलेज से तो तड़को डॉक्टर कहि पाले.
केबे जाइतले बेल ले जाइतले.
आगे बेल जो जाइतले तब 3 मास पूर्व जाइतले.
नै नै आपनकर बेल ऑर्डर टा हेची इंटरिम बेल ऑर्डर पास हेची 16/5/24
तर बहुत दिन पर से सर्टिफिकेट कॉपी नै की
किंतु आपन पर इंस्ट्रक्शन नै से सरेंडर कला कि नै या तो बुझन ऑलराइट लेखंतु द Learned Counsel for the appellant submits that as per the order dated 16/5/2024 passed in IA number 2017 of 2016, though the petitioner has been released on interim bail but he has no instruction as to whether, after availing the said order, the petitioner has surrendered before the learned trial court or not, and he is not in a position to produce the surrender certificate. Stop. In view of such submission made by the learned counsel for the appellant, let a report be called for from the learned trial court as to whether the appellant, after complying the has complied the order dated so and so in time or not. File be placed before the registered judicial will send email to the concerned court, and the report is to be submitted. Ara saptahere semane report debe. Matter be placed in the week commencing from 9th of December 2020. रिपोर्ट आसीबो लिख दियंतु 5 तारिख भीतर रिपोर्ट आसीबो 5 डिसेंबर 24 भीतर मैटर आसीबो 9th डिसेंबर 2020.
Item 24.
I am for the informant, my lord. Last occasional lordship directed and dated 14/11/2024, my lord. Kindly have a glance, my lord.
Which advocate the appellant
आपण पढिथिले से ऑर्डर टा लास्ट ऑर्डर टा
आज इंस्ट्रक्शन आई गॉट
11/2024 रे ऑर्डर टे पास हेतिला जे अपील टा फाइल हेची कोन टुटू आलियास सरोज जेना आउ सोनिया आलियास श्रीकांत जेना आउ सिप्पू आलियास नीरज कुमार जेना ना आदिर appellants अछन तो 2018 मसियारू फाइल हवा परे नंबर ऑफ एडवोकेट्स आदिरे सबू टाइम टू टाइम अपीयर करछन ये आइदर वकालतनामा देइछन्ती कि प्रिजनर्स पिटिशन तेणु वर्तमान से काहाकू चाहूची तारो एडवोकेट हिसाब रे कंटिन्यू करिवा पई
टुडे आई गॉट द इंफॉर्मेशन टुटू alias सरोज जेना एंगेज मिस्टर देवी प्रसाद धल टू आर्ग्यू द मैटर
आपण इन राइटिंग आनिछन्ती ना क्यों
नो राइटिंग
जेल सुपरिटेंडेंट को कहलेनी गोटे चिट्ठी लिखि दी दी थांदे आपनकर 3 जण अपेलेंट ना नहीं आते
3 जण दुईटा मरिगले 3टा बेल ले पळैछि
जे
वन ही केवल अछि
वेलफेयर अफेयर जाके
अच्छा हु इज डेड
सानिया एंड सिपू
अपेलेंट नंबर 2 इज डेड
से ता विषय ऑर्डर ही जाइछि अब जे अपील अबेट करिछि बेली आगुर केबे कहिथिले
and from the report has come.
let us report call for करिया पड़ो ना आपण तेमति मौखिक कहिदेल हमनी let us see that you are appearing for all the appellants in this. So you are supposed to file a death certificate. What is that? If you say that one of your appellant is dead now,
सर आपण रिपोर्ट मगे दियंतो
तो की डेथ की हैला
appellant 2
श्रीकांत जेना
गोटे मेमो फाइल टे कम से कम करंतु मौखिक करा हबनी you file a memo indicating therein that you have got the instruction that if you have got the authentic information, file the memo. Or otherwise, don't take risk.
रिपोर्ट मगे
अरे रिपोर्ट मागे गले गोटे
मेमो टे दियंतु
आ मेमो टा देबे जदी ऑथेंटिक इंफॉर्मेशन पाई जन
बस के लेखि के देइछन जे डेथ हे जेस तार बेली
पाई जन तो हां दो
यदि आपनकर इंफॉर्मेशन टा गोटे तांकर चिट्ठी ऊपर बेस करली सिया को लिखि दियंतु कोन असुविधा कोन फाइल करिवे अबिया फाइल कोन लेखो this criminal appeal has been filed by 3 appellants, namely Tutu alias Sarojena, Sania alias Srikant Jena, and Sipu alias Niroj Kumar Jena. Stop. The Learned Counsel for the appellant submits that the appellant number 3, Sipu alias Niroj Kumar Jena, has already been released on bail by this court as per order dated Okay, I'll give the order. ଆମେ ତ କିଛି ପାଉନି ଏଇ ଦେଖିଲ ଅର୍ଡର ସିଫ୍ଟ ଅଛି କି? ଅଛି ଅଛି 3 नंबर appellant ଗୋଟେ ଅର୍ଡର ଅଛି ରିଜେକ୍ଟ ହେଇଛି appellant number 1 ର ସେଟା ହଉଛି 19/2018 ରେ ତା ପରଠୁ ତ କିଛି ବେଲ ଫେଲ କି କାହାକୁ ଦିଆହେଇନି କୋଉଠୁ ପାଇଲେ ଯେ appellant number 3 ବେଲ ହେଇଯାଇଛି ନା ଭାବି ନେଲେ ଯାଇଛି ବୋଲି
ନା ତାପରେ ଅର୍ଡର ନାହିଁ
ନାହିଁ ତ ସେ କଣ କହୁଛି ଏମିତିଆ ସବମିଶନ କରିବା ପୂର୍ବରୁ ଆଟଲିଷ୍ଟ ସେଠି ୱାକମ୍ ଟେ ଅଛି ଅର୍ଡର ଗୁଡାକ ସବୁବେଳେ ଅପଲୋଡ ହଉଛି ଏଗୁଡାକ ସବୁ ଦେଖିବା କଥା ନା ନାଇଁ ଗୋଟେ ସବମିଶନ କରିଦେଲେ ଆପଣ ଛାଡ଼ନ୍ତୁ ସେ ସେମିତି ଅର୍ଡର କିଛି ନାହିଁ now you ଏଇ ଯୋଉ ମେମୋଟେ ଦିଅନ୍ତୁ ଦେଖନ୍ତୁ the land counsel for the petitioner files a memo indicating therein that appellant number 2 Sonia alias Srikant Jena is dead. Stop. Let the land counsel for the state obtain instruction about such submission through the IIC of Balichandrapur police station. The ghara seiti ha stop. The as per the order dated 14/11/2024, the London Council for the state is yet to receive the instruction as to whom the appellants intend to engage as counsel and seek some further time to obtain written instruction in that respect. ମୌଖିକ ଫୌଖିକ ନୁହଁ ଚିଠି ଲେଖିକି ଆଣିବେ ତାଙ୍କଠୁ ନହେଲେ ନେଇ ଆସନ୍ତୁ ଯେ ତାଙ୍କର ଗୋଟେ ଲେଟର ତାର ଦିଏ ମୁଁ ଅମକଙ୍କୁ ଏନଗେଜ କରିବାକୁ ଚାହୁଁଛି ତାକୁ ଆନେକ୍ସ କରିକି ଫରୱାର୍ଡ କରିଦିଅନ୍ତୁ ଆପଣଙ୍କର ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ତାଙ୍କ ଚିଠିରେ ଗଲା ହେଇଯିବ ହେଲା ଗୋଟେ କହୁଛନ୍ତି ମରିଯାଇଛି ତେଣୁ ଆଉ ମାନେ ଯଦି ନ ମରିଥିବ ତ ଭିତରେ ରହିବା କଥା କାରଣ ତାହାକୁ ବେଲ ହେଇନି ତେଣୁ ଏ ବିଷୟରେ ଇଏ କରିକି matter to be listed in the week commencing from 9th December 2024. Yes, please.
ମାନେ ইয়ার বেল্ট ডেথ ହେଇଛି ତାମାନେ କଷ୍ଟ
ଯୋଉ କୁଆଡେ ପ୍ୟାରୋଲ ଫେରୋଲ ଯାଇକି ସିଏ ତ ନାହିଁ ଡେଥ୍ କଥା ଆପଣ ଜାଣିନେବେ ପ୍ୟାରୋଲରେ ଯାଇଥିବ ଡେଥ୍ ହେଇଥିବ ଅଲଗା କଥା ଅଦରୱାଇଜ ତ ବେଲ ଏଠି କୋଉଠୁ ବେଲ ହେଇନି Yes, next. 9 ତାରିଖରେ ଆସିବ ଏ ମେମୋଟି ଦିଅନ୍ତୁ along with ଲେଖିଦେବେ ଏଇ ଯୋଉ ଏଗୁଡାକ ହେଲା Yes, and next.
Item 25.
Lordship, in item 25, on behalf of BR Tripathi, your Lordship, may I please, your Lordship. Lordship, as per your Lordship's order dated 21/10/2024, Lordship, the letter of the Session Judge Raigada is at flag C regarding the availing of the...
Flag C?
Yes, your Lordship.
In view of so and so, I am promising my order dated has been pleased to release this on interim bail for a period of 3 months from the date of release with further direction. Although this order was passed on, but the convict through his advocate filed certified copy on bar or article, and accordingly the order for release was passed on so and so. Again, no bail bond was filed on so and so. The bail bond surety was submitted 14/8, after which he was released on bail and with a direction to surrender so and so. Since the convict has availed this so and so, এটা তা পূর্বর চিঠি is supposed to surrender on 14/11 কলান না নাই
Lordship, we have no instructions.
Instruction নাই আচ্ছা হো লিখুন period the later dated 26/10/2024 of the Land and Session Judge Rayagada, in which it is mentioned that the petitioner, the date of surrender of the petitioner was fixed to 14/11/2024 after availing the interim date period of 3 months. Stop. The Land Counsel for the petitioner appellant submits that he has no instruction as to whether on 14/11/2024, the appellant surrendered or not. Let a report be called for. Also, let the report be called for. Registered judicial mo give a report email, and that is to be played by next week. Date the one matter to be listed in the week commencing from 9th December 2024. Okay.
Grateful.
Item 26.
Yes, Mr. Robert. Robert ପୁରା ଇଏ ଆପଣଙ୍କର ପ୍ୟାନେଲ କୁ ପଳେଇ ଆସିଲେଣି
ପ୍ୟାନେଲ ପଳେଇଲେ
ଆସିଥିଲେ
My lord.
Yes, Mr. Item 26, Mr.
Yes, yes.
Item 20.
30. Item 30.
We are in item 26.
CRLA.
Sorry. Sorry, sir.
Yes, sir.
Item 27.
What is the delay pointed out? 10 days.
We have no objection, Your Lordship, on that.
IN number 823 of 2021. This is an application for condonation of delay in filing the writ appeal. The stamp reporter has pointed out that there is delay of 10 days in filing the writ appeal. Land counsel for the opposite party has no objection for condonation of delay. Stop. Accordingly, the delay in filing the writ appeal is condoned. IA is disposed of. This matter for admission next week, Asu? Admission
Yes,
time?
yes. Item 30.
49 I am for the petitioner. Matter to ଆସିଲା
29 yeah, Mr. S.P. Mishra on behalf of Mr. S.P. Mishra and senior advocate, mention was made to take up this matter on 2nd December.
I'm not informed.
Okay, we thought that you have been informed. He has some personal difficulties.
I am not informed.
Yes, sir.
My apologies, my lord. Item 28 was adjourned. I think I was not informed by the London
तो मेंशन करते नहीं हमें बाबूचू
Again,
बोले इंफॉर्मेशन है ये सही 2nd December को
my lord.
ଏଇଟା ଗୋଟେ ହେଇଥିଲା ଆମର ଏଇ ଯୋଉ ଆଇଟମଟା ଗୋଟେ ଫ୍ଲାଗ ଦେଇଦେଲେ ଡବ୍ଲ୍ୟୁ ଯୋଉଟା ସେଇଟା ଗୋଟେ ଏଇଟା ଇଏ କହିଥିଲେ ଚିଫ୍ ଜଷ୍ଟିସ୍ where member one of the member Mr. G. Satpathy should be there.
G. Satpathy. Oh, before
Okay, ଦେଇଦେଲେ
अभी ଆଉ କିଛି order ନାହିଁ
ନାଇଁ ତାପରେ ଅଛି ତାପରେ ଆମ ପାଖକୁ ଆସିଛି 2011 ଏବେ ଆଚ୍ଛା
ठीक है
item 25 filing the memo. I mean, permitted to verify the file, Your Lordship.
କୋଉ ଫାଇଲ
ଫାଇଲଟା ଦେଖିକି କୋଉଠି କି ବେଲ୍ ଯାଇଛି ଟିକେ ଦେଖି
ଆପଣଙ୍କ ପାଖରେ ପେନ୍ ଡ୍ରାଇଭ୍ ଅଛି ପେନ୍ ଡ୍ରାଇଭ୍ ଟି ଦିଅନ୍ତୁ ସବୁ ଅର୍ଡର ତକ ନେଇ ପଳେଇ ଯାଅ ହେଲା yes next
Item 30.
Correction.
of the cost title one I have referred the I.
Hon'Ble.
ଭୁଲ ହେଇଥିଲା ସେ ତାଙ୍କ ନାଁରେ ହେଇଥିଲା ଡେଜିଗ୍ନେସନ ଦେଇଛି ପର୍ସନ ବାଇ ଲର୍ଡସ୍ ଅର୍ଡର ଆର୍ଥର the proposed amendment has been made to incorporating the designation of the authority.
Procedural ନା ଗୁଡାକ ଦେଇଥିଲେ
ହଁ
ନା ଦେଇଥିଲେ
ନାଁଟା ଦେଇଥିଲି my lordship
that has not been done.
I have given the schedule and also for
one thing, my lord, I am just enlightened. Again, they are giving the name. Name was designation.
no, I am not giving name. My lord, I have given.
No, you have filed it.
Page 4.
The subsequent IA. My lord, I liberty to withdraw the previous IA and filed a.
No, ଆପଣ ଟିକେ ବର୍ତ୍ତମାନ ଯୋଉ ଆଇଟା ଆଜି ଆସିଛି
ହଁ my lord
ସେଟା ହଉଛି
15,197
ସେଟା ଆସିନି କି
15,740 740 ଟା କାଇଁ
ଆସିନି
That copy did serve to us also.
15740 of 2020 so
my lord ମୋ କତିରେ କପି ଅଛି ଦେଖୁନାହାନ୍ତି
ହଁ ଠିକ ନାଇଁ ଠିକ ଅଛି you have not given a copy to
I have given my lord even if
ନା ଆମେ ଫାର୍ଷ୍ଟ ଆଇଟା ପାଇଛୁ ଆଜ୍ଞା
ହଁ ସେକେଣ୍ଡ ଟା ଦେଇଛି ଏବଂ ମୋ ରିସିପ୍ଟ ଟା ବି ଆନେକ୍ସ କରି ଦେଇଛି
that copy I don't have.
Mr. Pari, the London Council is here. He submits that he is having a receipt with
receipt ମଧ୍ୟ ସେଥିରେ ଆନେକ୍ସ କରିଛି
so that
sir ଗୋଟେ ଫାର୍ଷ୍ଟ ଆଇଟା ଆମେ ପାଇଛୁ
no first
ସେକେଣ୍ଡ ଟାରେ ବି ରିସିପ୍ଟ ଦେଇଛି
second ଆଇ ରେ କିଏ ଆପଣଙ୍କୁ ଅଫିସ ରେ କିଏ ଜଣେ ରିସିଭ୍ କରିଦେଇଛନ୍ତି
କରିଦେଇଥିବ ମୁଁ ଦେଖିଦେଉ ତାହେଲେ
ଏଇଟା କଣ ଦେଖିବେ ଭେରିଫାଏ କରିବେ ନା ଆଲାଉ କରିଦବା
ମୁଁ ଟିକେ ଚେକ୍ କରିଦେଇ କାରଣ ବାଇ ନେମ୍ ଗୁଡା ସବୁ ଥିଲା ତ
ନେମ୍ ଟା ବାହାର କରିଦେଇଛି ସେ ଦେଇଛି
ଆମେ ଦେଖି ସାରିଲୁ
ତାହେଲେ ଠିକ ଅଛି କୋର୍ଟ ଲର୍ଡସିପ ଇଜ ସାଟିସ୍ଫାଇଡ୍ ଦେନ୍
IN number so and so this is an application for amendment after hearing the London Council for the petitioner. So also the London Council, the Solicitor General, along with Jahana Deithibe. The interim prayer made is allowed. Now this schedule of proposed amendment shall form the part of the writ petition. The London Council for the petitioner shall file a consolidated cost title.
Yes, consolidated by Monday.
Consolidated cost title by
Monday.
Giving a copy to the London Council for the Union of India.
Monday पर आकर
ଆପଣ ଦେବେ ଫାଇଲ କଲା ଆସିବ ଆଉ କଣ ମ୍ୟାଟର ବି ଲିଷ୍ଟେଡ thereafter